Kajingkam magakando ha kajala Meghalaya kadai jong upat ba kalong da khongpong haba pet ye kajing khen jing dia laong uba adan mela basayomaj unong thau an ka Voice of the People's Party na nongkram haba wanra ek resolution banyatai halor kajing ban khen ye ki kandon jong ka Meghalaya Transfer of Land Regulation Act khat khandai spa nyopuar ha ka singi basaw jong dorbar sanrai ka ying dorbar thau an kajala Meghalaya ha ka arpoi trik unai lur arjar pulai Uba ardan ulaong, bo real luom klam ka kando, uday lupa ubala yap. Bo labo jengkeli, ayu ka sarkar kalale, yaki ba penkenya kini ki kendon kani ka ak, kumus iem karat marwet hima meliam, but ki Deputy Commissioner ki bala ailat ban register jaka klam da bot yaki kendon. Ula kantoru ika jing yo alat ki we ki real luom bamday na Meghalaya, ban thied jaka haka jalla. Yaka niga resolution, la kershan ru daw ba renek tan lingdot tongkar, unong thau an ka UDP na mau korwat. Yakaniga resolution la jubab daw menteri ubare kmi yakatanat revenue jong sarkar jala uba kerman jala haka jingarap lang menteri rang ba ka jala u konrat ki sangma ubala ong bagi autonomous district council ru ki don kabor halor ka khando ka siap namar ka jingbom hon ya ka jubab uba ardan ula kentat banweng ya kaniga resolution but ulam phang u thomas sangma ula bojing kali haka yeng lucky don ki bakershan bat ki bapersha haka ba ki bapersha kila job da ka voice vote
Sri Arden Miller Wasamot, Emily, may kindly move.
Sir, I beg to move this resolution, sir. Whereas land is God's given right to the indigenous people, and whereas our leaders in the past had enacted a legislation, namely the Meghalaya Transfer of Land Regulation Act 1972 to prevent the alienation of land, and whereas rampant violation of the acts is taking place. Therefore, this House do now resolve to stop this gross violation of the Meghalaya Transfer of Land Regulation Act 1972.
Motion moved. Now you may initiate discussion.
Thank you, sir. Sir, as I have mentioned in my submission, that whereas land is a God-given right to the indigenous people, and whereas our leaders in the past had enacted legislation, namely the Meghalaya Transfer of Land Regulation Act, to prevent the alienation of land, and whereas rampant violation of the act is taking place. Therefore, sir, I stand here to raise my serious concern about the most important issue of the indigenous people. I don't want to be blamed that by the future generation that I did nothing to protect and safeguard the interests of the indigenous people. So, what an irony for those who claim to be broad-minded and have a mainstream thinking, and who are trying to create a narrative that we are too conservative, narrow-minded, and not exclusive. So, I wonder how many of those who could make it to this August House, and how many of those who could make it to the civil services if there is no special provision for the tribal community in the country in general and our state in particular. So we are asking the people to elect us in order to serve and protect their interests. Therefore, sir, as member of the Voice of the People Party, we will do anything at our disposal to ensure that the rights of the indigenous people are protected, and also at the same time, without compromising the constitutional rights of non-indigenous people who are residing in our state. So, I would like to remind this August House that land for a tribal does not only mean for him to make a living, but also has a deep cultural and historical connection. It is the bedrock of a sense of security and freedom from fear. It is an important part in the lives of the tribal people in the hills, and for them, it is a matter of life and death. They are so much attached to the land, and any attempt to displease and alienate them would amount to obliterating the tribal community and would certainly meet with fierce resistance. So, on behalf of the present generation of the indigenous people, I must express my indebtedness to those who were instrumental in enacting the Meghalaya Transfer of Land Regulation Act in our state. We owe them for their far-sightedness, which have been a blessing to us. However, sir, it is saddened to learn that current generation of political leaders have diluted the provisions of this act to satisfy their personal and political goal. Sir, the insertion of section 41E and F in the Meghalaya Transfer of Land Regulation Act 1971 by an amendment brought in 1991 ensure the rights of religious societies for transfer of land in their name. These sections relates to land proposed to be transferred for a place of public religious worship by any community or as burial or cremation ground. These two sections opened a door for non-tribals to purchase land in Meghalaya, which was a departure from the inherent character of the Act. These sections were inserted by the state government on its own accord, as if the land belonged to it. So, the two sections also did not provide a scope for the indigenous communities or the traditional heads to have any say in the transfer of land, resulting in the government having the liberty to permit alienation of land under these sections. So the implementation of the two sections has resulted in the loss of large amount of land to non-tribals. It has also given rise to the emergence of a new class of landowners who were from outside the state and brought in huge workforce, leading to an unabated influx that was unprecedented in the last 50 years. Therefore, sir, I strongly feel and demand from the government that these two sections should be deleted. Sir, again, there was a new attempt to weaken the Meghalaya Transfer of Land Regulation Act. Recently, there was a proposal from one of the ministers in the state government to allow doctors from outside the state to buy land in Meghalaya to address the shortage of specialist doctors in the state. So this is very dangerous propositions and should not be considered at any cost. So even the decision of the government to allot land to the bureaucrats at the new Shillong Township is a clear violation of the Land Transfer Act. So I must mention here that the state cabinet took a decision on August 9, 2007 that the cabinet directed the revenue department to examine the feasibility of allotment of land to the professional, bureaucrats, etc., who could contribute to the development of the state. In pursuance of the cabinet decision dated 9 August 2007, the minister in charge of Urban Affairs Department, based on the view of the Revenue Department, approved the allotment of land of 45.01 acres in the new Shillong Township to the Civil Services Officers Housing Cooperative Society Limited. Accordingly, the Joint Secretary of Urban Affairs Department, under her letter dated 18 August 2008, issued the allotment order for allotting 45.01 acres of land at rupees 19 lakhs 60,636 only. And the annual land revenue is fixed at rupees 494 per hectare. As such, the one-time premium of rupees 19 lakh 60,636 rupees in effect works out to 1 rupee per square foot. Sir, the transfer of land to the Civil Services Officers Housing Cooperative Society Limited through a lease is illegal under the Meghalaya Transfer of Land Regulation Act 1971. Section 3 of the Act prohibits the transfer of land in Meghalaya by a tribal to a non-tribal or by a non-tribal to another non-tribal, except with the previous sanction of the competent authority. Section 2 of the Act, Section 2D of the Act defines transfer of land means conveyance of land of one person to another and includes gift, sales, exchange, mortgage, lease, surrender, or any other mode of transfer. Hence, the lease of government land to the New Shillong Township to the Civil Services Officers Housing Cooperative Society Limited is a violation of Land Transfer Act because there is no provision in the Act. So, in Para 2E of the Meghalaya Transfer of Land Regulation Act, it explains about the definition of a tribal. Tribal means a person belonging to any of the scheduled tribes pertaining to Meghalaya, and as specified in the Constitution, Scheduled Tribes Order 1950, as amended from time to time, and for the purpose of this Act shall also include Rabhas and Kashuris residents in Meghalaya. However, sir, it is very disheartening that there has been an attempt to misinterpret this very definition to encourage other tribal not belonging to Meghalaya to purchase land in Meghalaya on the pretext that they are included in the list of Scheduled Tribes Order 1950. And as a result of this misinterpretation, sir, lots of other tribals from other states are now purchasing land in our state, especially in the southern parts of the state, which is clearly in contravention of the Act. So we know that the dictionary meaning of the word pertaining means to be connected with a particular subject, events, or situation. And also the word specified, which is the past tense of specify, means to explain or describe something clearly and exactly. So, sir, we understand according to the definition, therefore, that no other tribal other than the tribes pertaining to Meghalaya, which is the Khasis and the Garos, we cannot consider Mizos, Nagas as tribes pertaining to Meghalaya. So, therefore, sir, we have seen how they are trying to dilute this act, sir. So, we cannot also deny the fact that huge areas of land have only been alienated in the name of development. Land was given to the Nehu, Negrims, ICAR, airport, factories, armed forces. But what have we received in return, sir? What have we received in return? Have these institutions benefit the indigenous people? The answer is very clear, sir, and very simple, no. They have become an agent to facilitate the inflow of outsiders into our state only. Even the state government seems not having any interest to ensure that these institutions should render maximum benefit to the local people. So, we have also lost large tract of land in the border area. In the border area bordering Meghalaya and Bangladesh. In the wake of this border fencing, we have also lost huge tract of land in the interstate border in the wake of the MOU signed between the government of Meghalaya and the government of Assam. So, sir, the observation of Honorable Supreme Court has further strengthened our claim that no land can be transferred to other people who is not a tribal belonging to Meghalaya, and that a tribal belonging to Meghalaya is only the Khasis and Garos, including the Kashuris and Rabhas as mentioned earlier. So, sir, I would like to read a few observations of the Honorable Supreme Court in this regard. Sir, in the case, between Bir Singh versus Delhi Jail Board, sir, the court observed that if the special privileges or the rights granted to scheduled castes or scheduled tribes in a particular state are to be made available in all the states, and if such benefits are to be carried from state A to state B on migration, the mandate of Article 341, 342 would get compromised. So, another observation of the Supreme Court is that insofar as the majority view is agreed with that a person who is recognized as member of scheduled castes, scheduled tribes in his original state will be entitled to all the benefits of the reservation under the Constitution in that state only, and not in other states. Union territories are not entitled to benefits of reservation in the migrated state and union territory. I would also like to read out the case between Badharam in bracket D versus Jasaram. So this is related to the land. The appellant, being a scheduled caste belonging to the state of Punjab and being an ordinarily and permanent resident of the state of Punjab, cannot claim the benefit of scheduled caste in the state of Rajasthan for the purpose of purchase of land belonging to a scheduled caste person of state of Rajasthan, which was given to original allottee as scheduled caste landless. So another observation of the Supreme Court is that, but so far as the present constitution stands, a member of the scheduled tribe going outside the scheduled area or tribal areas would certainly not be entitled to carry with him the privilege that he is entitled to when he is residing in a scheduled area or a tribal area. So, sir, this court ruling vindicated the stand that we cannot allow the transfer of land in Meghalaya to other than the tribal pertaining to Meghalaya. So, I would like to know, since there has been a rampant violation of Meghalaya Transfer of Land Regulation Act, I would like to know what action has been taken against those people who are involved in the selling away of our land to the people who are not covered by the Land Transfer Act, especially the same of Raj Marwet, who have voluntarily engaged in this illegal act. Moreover, sir, what action will be taken against those deputy commissioners who are willingly registered these lands which are in direct contravention to the provision of the law? So I have many copies with me here which substantiated my claim. These are the documents that I've received about the purchase of land in the southern part of our state and which were involved by this same right of Marwet. So that I will not be blamed that I just charge anyone without any proof. So, sir, I would also like to express in a very categorical term, sir, that when we talk about the issue of ownership of land, we did not try to separate it from the ownership of its wealth, including mineral and under the surface of our land. So this has been vindicated by the landmark judgment of the Honorable Supreme Court. So in a judgment dated July 8, 2013, which was delivered by a bench led by Justice R.M. Lodha, comprising Justice J. Shillong Mail and Madan B. Lokur. The court observed that a janmi or the hereditary owner has exclusive right not only of the soil under his possession, but also the subsoil and minerals underneath the surface of his land, unquote. So the court pointed to statutes such as Coking Coal Mines Nationalization Act 1972 and Coal Bearing Areas Acquisition and Development Act 1957, which only contains express provisions for acquisition of the mines and rights in or over the land for which coal is obtainable. It also said that even the Mines and Minerals Development Regulation Act 1957 only regulates mining activities. The act does not in any way purport to declare the proprietary rights of the state in the mineral wealth, nor does it contain any provision divesting any owner of a mine of his proprietary rights. So, if the understanding of the state of Kerala that in view of the provisions of the Mines and Mineral Development Regulation Act 1957, the proprietary right is in mines stand transfer and vest in the state, it would be wholly an unnecessary exercise on the part of the Parliament to make laws such as the ones mentioned above dealing with the nationalization of mines, the judgment observed. Further, sir, the court pointed to the Atomic Energy Act 1962 and the Oil Field Regulation and Development Act 1947 and said both do not contain provisions declaring that the state has property rights over subsoil minerals held by private landowner. Even with regard to the minerals which are greatly important and highly sensitive in the context of national security and also the security of humanity, like uranium. The Atomic Energy Act 1962 only provides under Section 5 for prohibition or regulation of mining activity in such mineral, the judgment observed. So, while I discuss the issues related to the need to protect the interests of the local indigenous people in terms of the Land Transfer Act, I must also mention here another need. The need to protect the poor and landless. Today we are witnessing, so some rich individuals possessing vast tracts of land as their private property. Persons who have money buy land as much as they can, sir, in the urban areas, semi-urban and rural areas, and the thirst for more land seems insatiable, sir. The poor and the landless have been reduced to mere tenants for the rest of their lives. Therefore, sir, it is high time that the government brings in certain law to curb this aberration and to ensure that the poor too can have a plot of land to build their homes or own some land. So according to the provisional data from the socio-economic and caste census 2011 for rural India released in New Delhi on the 3rd July 2015 revealed a sorry state of affairs as far as the number of households that hold no lands is concerned. So the data reveals that out of 80,43,896 households located in rural areas in the northeastern region, only 33,06,326, that means 41%, have land, while 47,37,457, 59% households are landless. Across rural India, sir, there are 7,83,78,173, 44% households with land, and 10,07,77,240, 56% households
Mr. Speaker,
with
sir,
no land.
I'd like to raise a point of order under Room 279-2 that a private member may not read his speech, but may refresh his memory by reference to the notes.
No, sir,
so
I'm
the
not
honourable
reading.
member is continuously reading from the notes. Sir, I would like to request you if the rules can be followed, sir.
So I'm not reading, sir. I'm just refreshing my minds. So, sir, when it comes to figures, I have to check, sir, because it is not right for me to just, because I think no one here will be able to remember, to memorize the numbers when the numbers are great, sir. So there's no harm for me, sir, I think, to look at the numbers in order to make sure that the numbers I've given in the House is correct, sir. Yeah, I'm coming to the conclusion, sir. So among the northeastern states, Sikkim, sir, has the highest number of households with land, and from the total rural household of 88,723, there are 53, sir, 1,399, or 60% of the household hold land, sir. So the state with the least number of household with land is Mizoram, followed by Meghalaya. Most of the land in Meghalaya is privately owned land, sir. Out of 4,85,913 households, there are only 1,16,723. That means 24% only hold lands in Meghalaya. So we used to feel proud of our uniqueness as far as the land holding system is concerned. And we used to claim that in Meghalaya the land belongs to the people. But sir, when you look at the data, it speaks otherwise. So land ceiling is required in our state to reduce economic and opportunities disparities. So to ensure that wealth is not concentrated in few individuals, and to ensure that all citizens have access to appropriate means of subsistence and piece of land. So Article 38 of the Directive Principle of State Policy talk about reducing the disparities in income, status, amenities, opportunities, etc. Further, the Article 39 of the Directive Principle of State Policy aims to prevent the concentration of wealth in a few people. As mentioned earlier, sir, that land is a life. And there is a very popular saying that a tribal without a land is as good as dead only. So, sir, if there is no land selling, wealthy people will purchase the entire village worth of land. Land selling system will help put an end to landlordism practiced by large landowners and rich individuals. So this is a very issue, sir, serious issue, sir. When it comes to land, we know it was told by the world historian that one of the causes that drove the Jews to fight for their own state was their attachment to their ancient land. So, and on the 29 November 1947, when there was a resolution in the United Nations for the creation of a Jewish state, the Jewish people on this particular day, they prepared for a war. They told that war is inevitable for the Jewish people, because if the vote is yes in the United Nations, the Arab people will declare war on us. And if the vote is no, we will have to declare war on the Arab people in order to achieve the goal. So when it comes, therefore, to the identity, even names matters. Even names matters. So let me inform this August House that any community would love to prove his identity. David Green, when he was a scribe, he used to write news report, and at the end of the news report, he put his name, David Green. And when he looked and pondered about his name, he realized that no one would know that I'm a Jew. So therefore, everyone in the world should know that I'm a Jew. So he scratched the second name Green and replaced with another one, Ben Gurion. From that day, he told that I'll be known as David Ben Gurion, who was the first prime minister of Israel. That is a kind of a mindset that the people are having in order to prove that they want to show their identity. And their attachment of land is one of the reasons that make the Jewish to get the Jewish state. So, sir, with these few words, I would like to resume my seat, and I would like to thank you once again for admitting this very, very important resolution, sir. Thank you.
Thank you. Any other members who would like to participate? Yeah. Renik Sontonka.
Sir, I also rise not to support the resolution, but to participate on this very important resolution. It is very, very important to all of us to understand about the importance of land, as we all know that it is very, very important to each one of us. The mover of the resolution has put to say that land is a God's given right to the indigenous people, I would love to add more by saying that land is a God's given right to the indigenous poor people to own land. I would love to know if there is any rules on this earth and in the state of Meghalaya to ensure that each and every poor people can have land to build their house at least. It is sad to know, sir, that there are so many poor people even in the village, in the rural areas. When they got a scheme from the central government to build their own house, they have no place to build their house. It is sad to see that even in rural areas, people they don't have land to build their own house. Yes, we are happy to see that our own people, our indigenous people, they are owning big land in the village, big land even in the city, but our poor people are having no land even to build their own small house. Sir, I would subscribe to say, if there is any rules, any law to restrict holding of land in the state of Meghalaya, which is, I know it is very difficult, but it is very, very important. There are many among people, among the indigenous people, among our own indigenous people, who own land countlessly and cannot utilize at all. They utilize only 10%, whereas 90% is just left there without any utilization. Sir, it will be very, very good if our government can have time to think how to restrict holding of land. That people, that someone can have land, can own land according to the purposes. Someone who want to buy land should have a purpose on it. What to do? At least the government, while registering the land, they may put the clause there that a person who buy the land and to register the land, they should have the purpose. What to utilize this land? Whether it is for agriculture, whether it is for tourism project, or whether it's for any kind of project. A person who own land, a person who buy land should have a thought in mind what to use of this land, because we want that the land should create revenue. The land should have revenue to the state of Meghalaya and to the people at large. Therefore, it is very, very important, sir. We want to see there are so many unutilized land in the state of Meghalaya. We have seen everywhere. But if we try to get the information, it has been owned by Master A, Master B, anywhere in the state of Meghalaya. Whereas there are many poor people who need just small plot of land to do cultivation. They don't have land for the cultivation as well. Therefore, one of the reasons of our farmers, when we try to find out why our people are not that lazy, but why they don't have their farm. We still buy meat from outside. We still buy our food product from outside. Why? The main reason of this is that because our farmers, they don't have land for their farming. They don't have their own land. Therefore, it is very, very important if our government can think how to help our poor people to own the land, at least to build their own house, and if possible, to assure that our farmers get the land to do their farming. Sir, I would request, if it is possible, our own government to think this very seriously about another problem on land which we have seen it arises everywhere, and that is land problem for bringing development. We all agree the fact that we need development. Why not? We need roads, we need water supply, we need electricity, which is the basic need in life. But there are times that we do not get to do this development because of land problem. There are several times. With my own experience, I have tried to resolve so many times of the land problem. There are times that I could resolve by intervening personally and solving the problem by different means. But every time we cannot do that, sir. There was a time that I had solved land problem by doing different means to get the road constructed to connect the 5 villages. I have to try by all means to convince the landowner. But there was another road pending till now for which I could not solve because the landowner, they are not parting the land. The road is going to go to another 5 villages, but the villagers residing at the upper hills, there are 2-3 of them, they don't want to part with the land. They are not ready to allow the road to be constructed through their land. And just see what will happen to the fate of those people residing down there. 3 villages, big villages residing down there. They are not sure to get the road connectivity because the villages, the people residing at the upper hills, they are not allowing to go ahead with the work. Sir, how many times we can intervene personally like this by involving ourselves when there is no law how to regulate this problem? Sir, I want to request our own government, if we can have time to fully discuss as a special resolution how to solve this kind of problem, to see the light of the day that all developmental projects, which is the basic needs of people, road projects, water supply, electricity, which is the basic need of people, we have to ensure that by any way we have to reach to the people with this basic needs. But if this kind of problem arising everywhere, the government is helpless. Sir, I feel personally it is high time for us to find out ways and means how to solve this kind of problem legally. And I propose that it is very, very important to have a special resolution on this to discuss in this house how to solve this kind of problem. Therefore, sir, I want to put this suggestion that it is very, very important to have a law in place that for the basic need of the developmental project that is required by the government, people in the state should understand to part and to be part of the project and to allow the government to carry on such basic need developmental project to ensure that each one of us can see the light of the day. With this few words, I resume myself, sir. Thank you.
Kyrwoh. Any other member? If there is no one to participate, may I request the Minister in charge to make a reply, please.
Mr. Deputy Speaker, sir, I am grateful to the honorable member from Nongkrem Assembly Constituency, Shri Arden Miller Basai Moi, for having raised this resolution for discussion in this autumn session 2023 as follows. This House do now stop this gross violation of the Meghalaya Transfer of Land Regulation Act 1972. Sir, Meghalaya was established as the 21st state of India by the Northeastern Areas Reorganization Act 1971, bounded in the north of and east by the state of Assam, south and west by the country of Bangladesh. The new state of Meghalaya on 21st January 1972 comprised of the United Khasi, Jaintia Hills District and Garo Hills District. Sir, alienation of tribal lands is a very sensitive issue, and the government of Meghalaya since the inception of the statehood has tried to tackle it comprehensively by enactment of the Meghalaya Transfer of Land Regulation Act in the year 1971. The purpose of enactment of this act is to regulate transfer of land in Meghalaya for the protection of the interests of the scheduled tribes of the state. The Act came into force in the year 1972. The Meghalaya Transfer of Land Regulation Act 1971, Meghalaya Act 1 of 1972, extends to the tribal areas within the state of Meghalaya as specified in Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution, subsection 2 of section 1. With the enactment of this act, land in Meghalaya, which includes immovable property of every description and any rights in or over such property cannot be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with provision sanction of the competent authority, and any transfer of land made in contravention shall be void and shall not be enforceable in court. Sir, the Act has various provisions which fulfill the intent of legislature when it was enacted, and I would like to highlight some of the important provisions as follows. Section 3, it mentioned that no land in Meghalaya shall be transferred by a tribal to a non-tribal or by a non-tribal to another non-tribal except with the previous sanction of the competent authority. The section was further strengthened by an amendment as early as in the year 1973 by Act 1 of 1973 by adding a proviso which stated that provided that the government of Meghalaya is satisfied may from time to time by notification prohibit any transfer of land within such area or areas as may be specified in the notification, and thereupon the competent authority shall not sanction any such transfer of land under the provision of this Act within such area or areas. During the course of time, this section was further amended by the legislature in the year 1991, Act 11 of 1991, which added another proviso which stated that provided further that no notification made under the preceding proviso shall apply to transfer the land for any of the purpose mentioned in clause E or clause F of the subsection 1 of section 4. Therefore, sir, the two important exceptions allowed by amendment of 1991 are: number 1, section 41E, whether the land proposed to be transferred is required as a place of public religious worship by any community or as burial or cremation ground. 2, sir, section 41F, whether the land sought to be transferred is for the purpose of implementing a scheme to promote in the interests of the tribals in the field of education or industry. Section 4, this section lays down in the details the procedure to be followed in any matter of the transfer of land. It mentioned that in granting or refusing sanction under section 3, the competent authority shall take into account the following matters according to the circumstances of each case. A, whether the non-tribal holds any other land in Meghalaya. B, whether there is any other tribal willing to take the land on transfer at the market value. C, whether the non-tribal seeking to take the land on transfer is carrying on any business, profession or vocation in or near the area, and whether the purpose of such business, professions or vocation it is necessary for him to reside in the area. D, whether the proposed transfer is likely to promote the economic interests of the scheduled tribes in the area. E, whether the land proposed to the transfer is required as a place of public religious worship by any community or burial or as burial or cremation ground. F. Whether the land sought to be transferred is for the purpose of implementing a scheme to promote the interests of the tribals in the field of education or industry. This section also mandates the competent authority to record its decision in writing along with the reasons thereof. Mr. Speaker, sir, at this juncture, I would like to highlight that since the enactment of this Act, certain exemptions which have been put under Section 11. This section contemplates that nothing certain in this Act shall apply to a. Any transfer of land as security for any loan granted by such banking company, cooperative society or other credit institution as the government of Meghalaya may by notification specify in this behalf, provided that a banking company, cooperative society or other credit institution as notified about by the government of Meghalaya shall not transfer any land to a non-tribal except with the provision with the previous sanction of the competent authority as provided in Section 3. B. The letting out of rent of any building standing on land. C. Any transfer of land to or in favor of government or district council. D. Any transfer of land to or in favor of, number 1, any company, cooperative corporation, society including cooperative society, autonomous body or association, wholly or substantially owned and controlled or managed by the government and which the government of Meghalaya may by notification specify in this behalf. 2. A municipal corporation, municipality or town committee constituted under any law. Sir, the government of Meghalaya in the Revenue and Disaster Management Department regulates various applications on matters relating to, number A is a transfer of land which include gift, sale, exchange, mortgage, lease, surrender, will. B. Change of land use of leased land. C. Inclusion of deletion of names in the lease documents of the leased land. D. Regularization of excess area of the leased land. E. Settlement or allotment of land, of government land. The government has put in place various safeguard mechanisms to ensure that the provisions of the Act are followed stringently. Some of them are as follows. The notification dated 7 June 1978 prohibits transfer of land by a tribal to a non-tribal or by a non-tribal to another non-tribal within the areas specified below. 1. The area within the East Khasi Hills district except the area to which the Act aforesaid does not apply. 2. The area within the Jainti Hills district. 3. The areas within the West Khasi Hills district. And number 2, sir, the notification dated 2nd February 1979 prohibits transfer of land by the tribals to non-tribals or by non-tribals to another non-tribals within the areas specified below. Number 1, the areas within the West Garo Hills district except the areas within Moza. Number 6. Number 2, the areas within the East Garo Hills district. 3, sir, allotment or settlement of vacant government land for private purpose will no longer be considered as per Office Memorandum Number RDS 28/92/27 dated 24th June 1998. Renewal of lease and enhancement of land revenue for government land lease to individual has to be renewed after a period of 30 years as per Office Memorandum Number RDS 69/87/25 dated 25th January 1988. The procedure to be adopted for revenue clause by way of lease agreement in which the departments, while processing any case, abides by the Meghalaya Transfer of Land Regulation Act 1971 and Meghalaya Transfer of Land Regulation Rules 1974 has been clearly indicated in instructions issues white letter number RDS 53/86/PT/91 dated 20th June 1998. For transfer of government revenue land, government to lease, Rule 4, 5 and 6 of the MTLR Rule 1974 and direction of government in the revenue department from time to time are followed by the competent authority while processing any application of land transfer. For transfer of land from tribal to non-tribal, especially to companies, Rule 4, 5, 6 and single window agency clearance, concern to operate, concern to establish, NOC from district council and local authorities, inspection report, maps, land documents, public notice and directions of government in the revenue department from time to time are followed by the competent authority while processing any application of the land transfer. Clause 4, 5, 6 and 19 of the lease agreement issued by Deputy Commissioner specified certain conditions which are the number 4, sir, that if the land is utilized not for the purpose it was leased out without the permission of Deputy Commissioner, it will deem to be breach of the lease term liable to be determined under Clause 19 of the agreement. Clause 5, sir, that if the land is not put into use within a period of 10 years from the date of issue of lease, the government reserve the right to cancel the lease and to take over the land and dispose it of in the manner the government deems it fit. Clause 6, that on the said land being surrendered under Clause 5, the government shall pay compensation for the building and other structures, including trees planted and raised by the lessee at an amount as may be valued by the Deputy Commissioner. Clause 19, that on determination of the term of this lessee, his or her respective and assigned shall have the first offer of renewal thereof on terms to be fixed by the government, and that if such offer is refused, the lessee interest or that of his or her respectively and the interest of anyone holding through or under him or his or her representative and assigned as tenant, mortgage or otherwise shall absolutely cease and determine. Mr. Speaker, sir, one important aspect of land administration in our state is that under Section 3 of the 6th Schedule to the Constitution, the management of land and forests also vests with the Autonomous District Council, which are empowered to make law with respect to land management and administration. These three district councils in the state of Meghalaya, namely Khasi Hills Autonomous District Council, Jaintia Hills Autonomous District Council and Garo Hills Autonomous District Council, the respective district council, which under the 6th Schedule of the Constitution are empowered to make laws with respect to the land management and administration extra, have enacted respective legislation touching upon the basic land system of the areas under their jurisdiction. The Khasi Hills Autonomous District Council has enacted the Khasi Hills Autonomous District Council Regulation and Administration of Land Act 2021 with the objective of codifying and making provisions for the regulation and administration of land in harmony with the prevailing practice of land tenure system in Khasi Hills district without deviating from the existing customary practice. The judicial pronouncement of the Honorable Supreme Court, the objective of the aforesaid codification is to protect and conserve the land tenure system prevailing in the tribal areas of the Khasi Hills, to preserve the socio-cultural and economic characteristic of the Khasi society. The Kyrwoh Hills Autonomous District Council has enacted the Kyrwoh Hills Autonomous District Land and Revenue Regulation 1954, which deals with land tenure or ownership, including heritable and transferable rights, land selling, land assessment, etc. The Jaintia Hills Autonomous District Council has enacted the Jaintia Hills Autonomous District Council Management and Control and Assessment and Collection of Revenue Regulation 1968 with amendments. Mr. Speaker, sir, the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement Act 2013 also lays down certain safeguards to check the land alienation amongst the tribals in general. One of the purposes of this act is to ensure safeguard against displacement in consultation with institutions of local self-government by way of special provisions have been made for scheduled tribes under section 41 and 42, which protect their interests. As per section 41.1, as far as possible, no acquisition of land shall be made in the scheduled areas. As per section 41.2, where such acquisition does take place, it shall be done only as a demonstrable last resort. As per section 41.3, in case of acquisition or alternation of any land in scheduled areas, the prior consent of the concerned Autonomous District Council is necessary. The RFCTLARR Act 2013 also lays down the procedure and manner of rehabilitation and resettlement. In short, the Act provides that any land acquisition in the tribal areas of Meghalaya shall be done with the consent of the Autonomous District Council. In conclusion, sir, in view of the above mentioned points, it is clear that the government, while processing any case of transfer, mutation, mortgage, will, etc., proceed as per the provision laid down in the Meghalaya Transfer of Land Regulation Act 1971, Act 1 of 1972, and the Meghalaya Transfer of Land Regulation Rules 1974. As of now, no such matter of the gross violation of the Act has come to the notice of the government, and I would like to impress that the intention of the government is very clear on the matter of transfer of land, and that the Act and rules are followed in the letter and spirit so as to protect the interests of the scheduled tribes of the state. I therefore request the honorable member to kindly withdraw the resolution. Sir, with this submission, I resume my seat. Thank you.
The mind of the mover, whether the honorable mover will withdraw his resolution.
So, can I get some clarification before I decide to withdraw?
Yes, please.
I would like to thank the Honorable Minister for his reply. And there are certain issues that I flagged during my submission, sir. And that is the purchase of land by other tribals, which is very rampant, especially as I've mentioned, in the southern part of the state. And because, sir, human nature, they will try to find a loopholes. So what they are trying to do, because I have also brought to the notice of this House the observation of the Supreme Court as far as the rights of other tribal from one state in another state. So, which is clear that no other tribal from other state can get the benefit in terms of lands or any other benefits that the tribal of Meghalaya, pertaining to Meghalaya, are getting. So, since this is rampant, so may I request if the government can consider, because there is a loophole that these other tribals, they are trying to purchase land by way of getting a PRC, to prove that they are the permanent residents of Meghalaya. So it is very easy, sir, to get a PRC in Meghalaya. I have here with me the application form when anyone would like to get a PRC in the state of Nagaland. There are many particulars that the applicants will have to fill in this 3 pages form. Whereas in Meghalaya, they need only, through the office of DC Deputy Commissioner, only 1 page where only 2 passport size of photographs, birth certificates, residential proof like EPIC, ration, certificates of all institutions. And there's no mention here about the role of the village daughter. But when it comes to the application for PRC in Nagaland, it seems to be more stricter than Meghalaya. So, sir, I think if we can block this loophole, we can prevent the alienation of land in our state to other tribal coming from other states. And so I would also like to, because in the course of his reply, the minister has mentioned about the role of the district council. So we have to understand that when it comes to the role of district council in transfer, the district council has no role as far as transfer is concerned. And this has been even observed by the Supreme Court, that district council is not mandated to make law on transfer, only for management. So we are not here to discuss about the management of land, we are here to discuss about the problem of transfer. So, and since we are a full-fledged state, sir, we have to also understand that we cannot bring into all the provisions of the 6th schedule. Because when the government of India decides to give us a full-fledged state, on that very day itself they have inserted para 12A in the Constitution of India, which is the overriding power of the state government. So therefore we should not find excuse that this is the jurisdiction of the district council and we have no jurisdiction at all as a state government. By para 12A, this is an overriding power that the state government. Therefore we need a uniform law throughout the states, sir. We do not have to have different legislation in different autonomous councils, sir. So, sir, my request for the government is that if the government can't plug these loopholes as far as the issuance of PRC is concerned, they can make more stricter, because any tribal who wish to be the resident of Meghalaya has to, ready to sacrifice being the resident of his state, sir. So, sir, if I can get that assurance, because there are many ways of violating the Land Transfer Act. There is a practice that even power of attorney also is being used to transfer land from a non-tribal to another non-tribal and from non-tribal, from a tribal to a non-tribal, sir. These are the 2 main concerns, sir, I would like to raise before the minister, and if the government can assure that they will look into it and make more stricter, then I am willing, sir, to withdraw my resolution.
Sir, I'll just put some more light on the reply that was given by the Honorable Minister. So first, I just want to stress on the fact that the Honorable Member has been mentioning about violation of the Act, sir. So what we are stressing on in our reply is that there is no violation of the Act as such, because any violation of any Act, so the constitutional provisions are there for the judiciary to be approached. So therefore, violation as per se of the Act and the provisions of the Act are not there. People have used different provisions for different ways and means. That's a different issue. But the violation in itself of the Act is not there. And I'm not saying that it's been done. I'm just referring to the Honorable Member's statement which he mentioned. So therefore, sir, I think first thing we need to clear that, that the Act itself is not being violated. Provisions are there, and based on those provisions, different purposes have been served, whether it's the education issues or industries issues, in all cases where there has been an issue of a non-tribal or any organization coming in, it is based on the provisions which is very much in the Act, whether through the original Act or through the amendment. So that's the first part. So the second part is regarding ensuring that these entire issue of the PRC that has to come in. Sir, we are all aware, sir, for the purpose of land as such, so the PRC is not a document that is used. It is more, PRC is more for issues like education. In all these areas, the PRC is used. Of course, they may ask for the certificates and all. Those details are not with me as of now. But for purchase and sale of land is not done. PRC is not as such a document and is not really applicable in that line. But, sir, I think the concerns that he is raising, sir, we have noted, sir. And yes, there are different areas which is mentioned that there are concerns. And I think as a member in this August House and as a citizen of this state, obviously, sir, we all share those concerns. And definitely, sir, the suggestions made by the honorable member and including the other members also had participated. So we will note all of that down. We will examine all these areas, whether PRC is the right way to do it or whether we have to see the definitions in the things. So we can examine all those matters. But as I said, from the primary resolution that was passed, as I said, I would like to stress again that there's no question of any violation of the Act. But as I said, the suggestions made by the honorable member, concerns have definitely been noted. We are also obviously all concerned about issues when it comes to the rights of the tribals of our state. And definitely, sir, we will examine all those matters as mentioned and find the best way possible on how we could move forward in these issues, sir.
So, may I know the mind of the mover, please?
Sir, I think I stand by what I've stated in this house, sir, that there is a violation. I don't know why the government is in the denial mode. So many people are purchasing land in Kyrwoh district. Those who are not supposed, to be covered by the Land Transfer Act. And I have a copy with me also. These are the people who have purchased land. So many people who have purchased land. So therefore, there is a violation of this Meghalaya Transfer of Land Regulation Act. I don't say that the government is violating, but the people, how can they purchase land when they are not the tribal pertaining to Meghalaya? And that is rampant in Kyrwoh district. So I stand by what I've stated, sir. But I also like to express my thanks to the government for willing to examine the points that I've raised. So, sir, therefore, to say that there is no violation of land transfer act in Meghalaya is, I think, is ill-informed, is not correct, sir, on the part of the government. There is, sir. I have copy with me also. I can even provide this copy to the government, sir.
So, you are withdrawing?
Yeah, I want to hear from them.
Sir, I have just like to read the provisions in the Act itself, where it defines tribal. It means a person belonging to any of the scheduled tribes pertaining to Meghalaya, as mentioned rightly, and as specified in the Constitution Scheduled Tribes Order 1950. And hence, sir, it is based on this particular definition that are there. But as I said, sir, the lands that have been transferred as per the provisions that are there in the Act itself, under those circumstances, I'm saying the violation is not there. Because, sir, if the violations are there, obviously, sir, for any violation that happens, the court and the judiciary is there where any citizen can go and seek justice saying that this particular law has been violated. And hence, this kind of case we have not seen, and in any of the situations where cases have been put forward, in those cases, the court has given orders, and wherever the court has given orders, the state government has then implemented those orders based on the court order. So I'm saying it from a pure judiciary and constitutional and the law point of view, sir. Whether the principle or the purpose of the Act is not being implemented and concerns being there, sir, yes. I'm not trying to say that there are no concerns, but purely from the Act point of view and violation point of view, because if there were violations, sir, any individual is free to go to the court, is what I'm saying. But nonetheless, sir, I just want to clarify that part. So therefore, if there are any concerns like this, sir, everybody is free to go to the court, and the court, obviously, whatever verdict the court gives, it will be implemented. But to look into it and examine on how we could strengthen it or change things, that's a separate subject, sir. So therefore, that part, as I said, we will definitely examine that matter, sir. But my stand in the point of violation is not in terms of the principle or the purpose violation, but in terms of the legal violation and the constitutional provisions and the provision of the Act that is there. In that terms, sir, the violation is not there, because the procedure has been followed. Otherwise, court would have come in, anybody would have gone for a court case, and there would have been an order from the court. So from that point of view, but from the principle and the purpose point of view, sir, as I said, the concerns that he has raised are there, and we will definitely, sir, examine this and figure out how we should move forward, sir.
Sir, I'm still not satisfied as far as those, since I've raised these issues specifically for those people who have purchased land in Riewspah district. So what will the government do? Because the definition itself explained about the tribal pertaining to Meghalaya. And it is this very definition that some people are trying to misinterpret, by citing that any tribal which is there in the tribal list of 1950. But the Act itself speaks about the tribal pertaining to Meghalaya, which means only the Khazis, Garos, Kashri and Rabhas has access. So, sir, what will the government do in order to stop that the purchasing of land in the Riewspah area?
Yes, so I'll just read out the line again. Tribal means a person belonging to any of the scheduled tribes pertaining to Meghalaya, and there's an and to it, and as specified in the Constitution Scheduled Tribe Order 1950. So the provisions are very clear, and based on these provisions, whatever is happening is happening. So the violation, as I said, if there, anybody is free to move to the court. So I want to segregate these two parts. So violations, sir, as per the provisions in the Act as of now, are not there. There's no violation. Otherwise, as I said, if there is violation, please can move to the court and court can take. Regarding reviewing it and looking into it and examining the whole purpose, I've said that I will definitely examine the matter and see what are the areas that are there and look back into it. But that is not part of this resolution as such, because it's talking about the current Land Transfer Act. If the resolution had mentioned specifically that amendments and this resolution resolves to amend the Act in this manner, then we could have discussed that aspect. But as I said, the violation. So I'm trying to be very, very particular with the words that have been mentioned. I am not saying no to the examinations. We will definitely examine. We have noted the concerns and we will see how to move forward. But whatever has been done right now, sir, is as per the provisions that are laid down in the Land Transfer Act, sir.
So, I think when we read about the provision of the law, we have to also understand that we need to read between the lines. We need to read between the lines. When the definition about the tribal means a tribal belonging to any of the scheduled tribes pertaining to Meghalaya, then who are the tribes pertaining to Meghalaya?
And as specified in the Constitution.
Yeah, and I will come to that. And specified. And I have already explained what does it mean by specified. Specified is a past tense of specified. That means to describe or explain something, clearly and exactly. That means this, the list of scheduled tribes or the 1950. That means the Khazis and the Garos have been included, specified in that list. It doesn't mean that all those tribals enlisted in the list will be, is pertaining to Meghalaya. If we take in that line, that means we are wrong, so we cannot rectify. So we have to understand that when that word "and specified," I mean, it's being specified in the list, which means the Garos and the Khazis has been specified in the list, not any other tribes coming from other states. That is where, that is where people have been misinformed, misinterpreted, that they are getting the benefits on land even in Meghalaya, which is not right if we go according to the observation of the Supreme Court, sir. So therefore, sir, we have to read between the lines in this portion. It means the list and specified. That means clearly explain and describe in the list, which means that the Khasis and Garos are included in that list. So we cannot take all those tribes in the list to be pertaining to Meghalaya. That is my contention, sir.
So that's the interpretation that the court will have to do. I think for us to say that we'll have to read between the lines, that's not how the law will work. As I said, if there are concerns about this definition of this, the court can be approached. But that is something that I don't want to comment on, because as I said, interpretation can be done in the court, and anybody who has any grievances can definitely approach the court. But as I said, the concerns that he has raised, we can examine those concerns.
So, finally, what is the mind of the mover, please? Whether you wish to withdraw or not?
So, this is a very serious issue, sir. And we have, as I've told, that we have lost large tract of lands in different forms. So I'm very, concerned that if we don't put a stop and if we don't do anything, maybe the government can issue a public notice as far as the interpretation of this, the word tribal is concerned. So I'm not, satisfied, so therefore, sir, I beg not to withdraw.
Okay. Since the mover has not withdrawn his resolution, I will put the question before the House. The question is that those who are for the resolution say aye. Those against say no. The noes have it, and the resolution is lost.